You see it?
Yeah. Yeah, I did not see.
I thought I sent it in, but it was pretty late.
No, you said you have it, but he hasn't signed it. I will send everyone their copy Monday morning before the hearing.
I was going to make it to my
Then
office.
I got another one says I hope so, waiting for meeting to start, but there was nothing attached. So, yeah, if you could get it over, I will sign it and get it filed. All right. We ready to go? Whoops.
Yeah.
Adam back. There he is. All right. Let's be on the record in two cases, those being 2017 CR263 and 2020 CR438, both captioned State of Kansas versus Devon Jacobs. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears virtually through Assistant District Attorney Adam Sokoloff.
May please court, defendant appears by Zoom video with counsel Anthony Russo, also by Zoom video.
All right. We are here set down for a revocation on the 2017 case and a plea on the 2020 case. What I intend to do is go ahead and take up the plea. We'll get that all done, and then we can dispose of the violation after that. Mr. Jacobs, to take up your plea, I need to ask you a bunch of questions, okay? Here's the deal. If I ask you something that you don't understand, you tell me that, and you and I will talk about it until we're sure that we're both on the same page, okay?
Yeah.
If at any time you want to talk to Mr. Russo before you answer my question, you just tell me that. I have the ability to send you guys to a private room to talk, okay?
Yeah.
All right. It is a little bit difficult to hear you with the mask and all, and my court reporter has to take everything down. So make sure, yeah, that's fine, and then speak up nice and loud. First things first, you need to be sworn in. So if you'd raise your right hand, my court reporter can swear you in.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Jacobs, how far did you go in school?
I made it to the 11th grade, but I got my GED in the Juvenile Correctional Complex in 2015.
All right. You read and write okay?
Yes, sir.
All right. Mr. Russo, I don't have it in front of me, but Mr. Russo told me that he went over that plea petition with you and you signed it. Is that correct?
Yes, Your Honor.
Okay, good. All right. Now, I know you're in custody, but I have to ask you, as you sit here today, are you under the influence of any alcohol, drugs, or prescription medicine that might cloud your mind, keep you from understanding what you're doing?
No, Your Honor.
Feel like your mind's clear today?
Yes, sir.
Do you know what you're charged with?
Yes, sir.
You know you don't have to change your plea from not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial. Do you understand that?
Yes, Your Honor.
At the trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Mr. Russo would help you throughout that trial. He could cross-examine and confront all of the state's witnesses, challenge their evidence. He could call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power of the court to make them come. At that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, Mr. Sokoloff here couldn't get up and argue to the jury, well, you should convict him because he didn't get up and tell you his side. Do you understand that?
Yes, Your Honor.
All right. Now, at the end of that trial, if you were convicted, you would have a right to appeal that conviction to the appellate courts. If you didn't have the money to do that, the court would appoint a lawyer to do it for you. Do you understand that?
Yes, Your Honor.
All right. If we take this plea today, you're going to be giving up all of those rights that I just talked about. There's not going to be a trial of any kind in this case. You understand that?
Yes, Your Honor.
All right. Your lawyer tells me, I'm going to put up here my copy of the information in this case. I think I have the right one. Can you see that?
Yes, sir.
All right. Now, your lawyer tells me that what the plan is today is that you're going to be pleading guilty to count 1. That's the aggravated battery, severity level 7 person felony. Count 5, which is aggravated endangering a child, a severity level 9 person felony. And count 6, aggravated endangering a child, a severity level 9 person felony. I was not told there are any other agreements as to sentencing or anything like that. Is that your understanding of the entire plea today?
Yes, Your Honor, as well as the state did a recommendation of a 2-year probation with the backup sentence being up to 48 months. That is my understanding of the plea. Yes, Your Honor.
All right. Mr. Russo, is that an accurate description of the plea?
Up to where he resided, Judge. The 48 is the maximum.
Right.
His criminal history is less than that, so his numbers will be less than that. But the numbers that we talked about were the maximums.
Okay. And Mr. Sokoloff, that's your understanding of the plea as well?
As it relates to 20CR438, yes, Your Honor, the other component would be the stipulation to violation of the old case.
Okay. And we might as well mention that as part of this hearing today, we're going to take up your revocation. My understanding is you're going to be stipulating to those violations. The court will order the sentence to be invoked, but that you've already served all of that sentence. Is that your understanding as well, Mr. Jacobs?
Yes, Your Honor.
Has anybody promised you anything other than what we talked about to get you to plead guilty today?
No, Your Honor.
Has anybody placed any force or threats against you to make you plead guilty today?
None whatsoever, sir.
All right. Mr. Russo, what's our understanding of Mr. Jacobs' criminal history score?
I believe he is a C. A C, Judge.
A C? All right. So, Mr. Jacobs, as a C, it looks like that controlling sentence at the top of the, or at the highest crime would be 25, 27, or 29 months. There would be a presumption of probation, but given that you were on probation at the time of the commission, you wouldn't have a presumption one way or another. Is that what you and Mr. Russo talked about as far as your criminal history goes?
Yes, sir.
Okay. So when we're done here, I'm going to order a pre-sentence investigation. All right. That's going to take a deep dive through all of your records and make sure what your official criminal history score is. Since I don't have that yet, what I have to do for today's hearing is assume you have the very worst possible criminal history. All right. That would be an A, so that I can advise you what the maximum that anybody could get for these crimes are. Do you understand that?
Yes, Your Honor.
Okay, so the maximum for the 7 is 34 months. And then for the 9s, since they're secondary counts, you wouldn't have a criminal history. The maximum for each of those is 7 months. So if a judge were to give you the maximums as a criminal history A and run them all consecutive, you could be looking as up to 48 months in prison and a fine of $100,000 on each count. Do you understand that those are the maximums?
Yes, Your Honor.
And those would carry 12 months of post-release supervision. You understand that?
Yes, sir.
I'm sorry, I think yes, that's correct. All right. Do you have any questions for anything that you and I have gone over today?
No, sir. I'm quite clear on everything that you've stated, sir.
All right. Mr. Russo, do you know any legal reason why your client should not now plead?
No, Your Honor.
All right. Then I'm going to ask you, Mr. Jacobs, as to count 1 of the information in the 2020 case charging you with aggravated battery, a severity level of 7 person felony, how do you plead, guilty or not guilty?
I plead guilty, Your Honor.
All right. As to count 5, the aggravated endangering a child, a severity level 9 person felony, guilty or not guilty?
I plead guilty.
And then as to count 6, the aggravated endangering a child, again, a severity level 9 person felony, guilty or not guilty?
Guilty, Your Honor.
All right. Now I'm going to ask Mr. Sokoloff to tell me what he thinks the evidence would be in this case I want you to listen closely because when he's done, I'm going to ask you if that's what happened, okay?
Yes, Your Honor.
All right, Mr. Sokolov.
And I guess the only other thing, Your Honor, I'm not sure. I don't think we covered it. The state waives its right to a prelim.
Right. Okay. Did you all have a prelim before we set this?
No, Your Honor, we didn't. This got up to you pretty quickly in that regard. So I just wanted to be the nerd here and waive my right to prelim.
You are absolutely correct. And Mr. Russo, on behalf of the defendant, you waived prelim today too.
Yes, Judge, we will waive.
All right. I'll find both parties have waived preliminary hearing, find the defendant over for trial, and we will continue with our plea. Thank you for that, Mr. Sokolov. Your factual basis, please.
Yes, Your Honor, were this case to proceed to your trial court, the state believes it would present to the court evidence that would prove for the counts pled to here today that on June 20th, 2020, that the defendant, Mr. Jacobs, engaged in a automobile we'll call it confrontation with another individual, and that confrontation culminated at the area of the parking lot at 38th and State Avenue, which is in Kansas City, Kansas, here in the county of Wyandotte. That in that parking lot area, that a vehicle controlled by Mr. Jacobs was intentionally driven into the vehicle driven by the other party there, obviously done so without permission or authority. That vehicle strike vehicle on vehicle counts per the Kansas statutes as a deadly weapon and in a manner whereby somebody could have been seriously injured. To wit, inside that vehicle were two minor children who were put in grave physical danger based on that battery with the vehicle. Those minor children we will refer to as DJ and DJ Jr. And those two, again, were under the age of 18 and present in the vehicle that was struck by the vehicle controlled by Mr. Jacobs. That happened 38th and State, June 20th of 2020, and would satisfy the three counts 1, 5, and 6, respectively, from the original information to which he pled here today.
All right. Mr. Jacobs, you heard what the prosecutor had to say. Is that what happened in this case?
Yes, Your Honor, it is.
Okay. All right. I will find that the defendant has freely, voluntarily, and intelligently entered into his plea. He knows the nature of the charges and the consequences of the plea and has acknowledged a factual basis sufficient for finding of guilt of the three charges to which he is pled. Therefore, I will find that he is guilty of those three charges. Per the plea agreement, the other charges in 2020 are dismissed. I'm going to order a pre-sentence investigation and set a sentencing. Let me see if I can get a hold of my assistant quick enough to get a sentencing date. And while I wait for her to do that, we will take up, well, let me finish with this one. Mr. Jacobs, as a convicted felon, it's prohibited for you to own and possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. You understand that?
Yes, Your Honor.
All right. And this is not a registration offense, as there was not a firearm used. Am I correct in that, Mr. Sokolov?
The state is not asking the court to make a deadly weapon finding.
Okay. All right. So I won't have to advise them about the registration. All right. Given that, is there anything else touching directly upon the plea that I need to take up before we switch our attention over to the revocation case?
Not from the state, Your Honor. Thank you.
Not by the defendant.
All right. Then as to 2017 CR 263, there was a motion for revocation filed, and specifically there was an addendum filed back in July in this case. I will share it at this time. It alleges one count of violation, and that is Mr. Jacobs' arrest in this present case, as well as his previous probation violation that was filed and the Bonner warrant. Mr. Russo, I think for purposes of our hearing today, it would be sufficient if your client was of a mind to stipulate to that alone. Mr. Sokoloff, any objection to that?
No, I think that's perfectly fine.
All right. And is that what he wishes to do, Mr. Russo?
Yes, Judge.
All right. So, Mr. Jacobs, you saw that violation that I had up there. Basically, it was based on your arrest in this case and for those other things. Do you agree that that occurred?
Yes, Your Honor.
All right. I will find the defendant has stipulated the violation. My understanding is the parties are asking me to impose a sentence. However, given credit sufficient at this time, the parties believe for him to have completely served that time. I'd ask you first, Mr. Russo, is that correct? And do you have any other comments about disposition?
Judge, that is correct. I believe if he had not served the time, by the time he was rearrested for the new case, having served this time on the new case, he will have gotten enough credit to have taken care of that first case.
Mr. Sokoloff, any comments?
Just so the court is clear and for your own edification, the underlying sentence was 7 months on the 2017 case. He has been in presently for just over 6 months and had over 50 days of credit at the time of sentencing initially. So there's no doubt in the state's calculations that Mr. Jacobs is more than satisfied that underlying time. I will also, just so the court knows how we got here, at the time Mr. Russo and I began negotiating this, we weren't sure. We were counting on our fingers and toes where Mr. Jacobs had been at. Certainly at this point, the court should have no concern that he's satisfied that 7 months. I believe even without good time credit.
All right. So you understand this, Mr. Jacobs, by operation of law, since this new case was committed while on probation in the other case, it's going to be mandatorily consecutive. So basically what the lawyers are going to do is they're going to figure out how much time you had left on your old case. You're going to be credited in that old case with all of that time, which will flatten out and end the sentence in that case. Whatever is left over, but only what was left over, will be credited to the new case. You understand that?
Yes, Your Honor.
All right. Are there any outstanding costs, fees, restitution that need to be sent to collections on that old case?
On the old case, Your Honor, no. I mean, I'm unaware. I can't remember if the first motion had some unpaid costs or not. It's not my intent to keep those out there. I think this case, obviously, if there's anything remaining, it's not a reason to extend him. Certainly, we're closing it out. So,
Right.
I'm not aware of any. On the new case, there will be restitution. I know that's not what you're asking, Your Honor, but
Right. It certainly doesn't allege in the original probation violation motion that there are outstanding costs and fees. Obviously, if there are any, those will be referred to collections. I'm not going to keep him on probation for that purpose. All right. My assistant has indicated that we are available on February 12th at 9 a.m. for his sentencing. I would prefer to do it by Zoom as long as everybody's okay with that. Mr. Russo, are you available 2/12 at 9?
Judge, I've got a pretrial conference at that time. I could do later that morning, like an 11.
All right, let me check my calendar and make sure that we don't have something at 11. Yeah, no, I'm wide open that day, so it looks like I can do 11. I'll just let my assistant know that that's the time. Mr. Sokoloff, you or someone in your office, 2/12 at 11 a.m.?
yes, Your Honor.
All right. Mr. Jacobs, I plan on letting you go today. Do you know how to get a hold of Mr. Russo?
Yes, sir. I do.
Okay, we plan on doing this hearing by Zoom again. So do you have the capability when you get out and get home to get on somewhere?
Yes, sir. I do.
Okay, you keep in touch with Mr. Russo. He's going to send me right now a PSI request. so that I can get it over to probation. Tony, do you have that information by any? Is it?
I
part
have
of
that, Judge. I was just gonna send it to Jesse
probation?
Dunn.
That's fine. Yeah,
Okay.
that's who you should send it to. All right. So they're going to be in touch with you in the next week or so. All right, to set up a pre-sentence interview. If you don't hear from them within, say, 2 to 3 weeks, you need to make sure you let Mr. Russo know that because something's gone wrong. All
Yes.
right. Otherwise, we'll expect. I'm going to set up the hearing for February 12th. I'm going to send the link to it to Mr. Russo, and he will share it with you. Okay.
Yes, Your Honor.
All right. Gentlemen, anything else for our record today?
Judge, just that as soon as I get back to my office, I'll be able to scan these documents in, and then that's when I'll be able to get everything sent around.
Sounds good to me. We are adjourned, and I'll just get that over. If you send me the plea petition, Tony, I'll sign it, get it filed, get that PSI request over to Ms. Johns. I'll also write up releases for your client and take them down to jail now.
And Your Honor, I guess at that point, when you get the plea petition, you can just note approved by the state on it. Obviously, I won't be able to sign the one that's signed by Mr. Jacobs.
Right. Okay. All right. I will note that on there before I file it. Thank you.